Good afternoon and welcome to another episode of Lunch and Learn. And this is a special edition, a whole week that we are discovering all the ins and outs of divorces. Welcome to everybody that registered for our Lunch and Learn session for today. My name is Eugene Opperman. I'm a family law practitioner. I've been doing so for the past 23 years. And I'll be happy to host this session together with one of my article clerks, Erin O'Neill, for today. And today we will be discussing, like I said, it's all about divorce, but we will be discussing the consequences of divorce, and more specifically, dealing with the common mistakes that one makes when it comes to divorce, and what is the difference between opposed and unopposed divorces. This webinar is proudly brought to you by our firm, by Oppermans Incorporated, and you're most welcome to drop us a line if you need some more information, or if you just would like to give us some general comments. You can drop us a line at eugene@oppermansinc.co.za, or even our generalized web address or email address on info@lunchandlearn.org.za. Just an overview of what we will be discussing today. Today we will be discussing, we'll start off with a simple topic that everybody wants to know. Is cheating a ground for divorce in South Africa? Then we'll be addressing the issues of the consequences of divorce and discuss, in short, the whole process of divorce in South Africa, with referencing to the common mistakes that one makes and that one needs to avoid when going through this whole divorce process. We will also be addressing the issues and the differences between contested and uncontested divorces, and give you some insight on how to fast track and how to make your divorce more cost effective, especially when it comes to unopposed divorces. I will also be addressing the issue of the costs of divorce, what it will cost you if you do it yourself, and if you employ the services of an attorney. And then Erin will take us through a brief explanation on how to prepare a divorce summons yourself without the need for an attorney. Just to get some logistics out of the way, you have once you have registered for this free webinar on our website, lunchandlearn.org.za, you would have received a link, and on that link that would bring you to this webinar, which is presented free of charge, of course. You will also have access to some pre-reading material, and then most importantly, like I always say, on the resource and templates tab, right at the top on the right-hand side, you would have access to the course handout, as well as the slides that we will be presenting today. If we are making reference to any of the case law, the legislation, and so forth, that will also be available for download on that specific tab called Resources and Templates. But without further ado, I think we can start. And let's start off with the contentious issue: is cheating a ground for divorce in South Africa? Now, when a person cheats in a marriage, there's a breakdown. There's irretrievable breakdown of trust in that relationship, and that is one of the key factors that the court would look at, and that would allow you to file for divorce. So just to give a simple answer, the answer is definitely yes. Cheating is definitely a ground for divorce, and we see that quite often where a third party is involved in a marital relationship, and that causes the breakdown thereof, the so-called third party that causes the animosity between the divorcing parties. So what one would do in terms of cheating is that in order to gather some evidence. Now, in South African law, we have, like we explained previously, is we have a no-fault system. So the only thing that you actually have to prove to the court is that the marriage has been irretrievably broken down. And obviously cheating would form one of the bases of that. So there is not specific evidence needed for the allegement of irretrievably broken down marriages, but surely the cheating thereof would play a major factor. Now, if you suspect that your spouse is cheating, yes, obviously you would need to gather some evidence thereof. You can take WhatsApp pictures, you could take the messages on WhatsApp, and so forth. So it might be a good idea if you approach an attorney and if you do suspect that your spouse is cheating, to gather some evidence beforehand. Now, be very careful if you gather these type of evidence that you do not infringe on legislation that actually prohibits you and protects the identity and the privacy of the other spouse. And I'm thinking specifically of the POPI Act that allows for protection of personal information. But in all instances, yes, most definitely you would have access to some of the banking statements if he squanders money, if he buys the X or the third party flowers and so forth, or expensive gifts. Yes, most definitely you could use the banking statements in order to prove that. Now, in terms of Section 9(1) of the Divorce Act, there is mention that, and we will be discussing that in a brief moment, there is provision that if the marriage has been irretrievably broken down, and it was the sole cause of one of the parties, i.e. then for cheating, then the court may make an order for forfeiture of the benefits of the marriage as a legal consequence. So that is available. Is it used in South African law? Yes, we do use that, and we ask in our particulars of claim, we ask for the forfeiture of some of the benefits, the financial benefits, because there was a third party involved. So that is most definitely that is available as well. So what are the consequences of divorce? A divorce has a beginning, or the marriage has a beginning and an ending, specifically when it comes to the divorce. So what happens? What are the consequences of divorce? What happens after the divorce? Now, in legal terms, there are a couple of consequences that we need to address. Now, obviously, the first one would be that there are some legal consequences. Now, legal consequences refers to the termination of the marital union. The parties are no longer together when they get divorced. Then obviously those responsibilities of the marriage would be terminated. There is also a reciprocal duty of support between the parties while they are married, that they have to look after one another. There are some rights and responsibilities with regards thereto, but upon divorce, upon the dissolvement of the marriage, then that comes to an end. And that is one of the legal consequences. And for all practical purposes, they are no longer seen as a complete unit anymore, but they have separate entities going forward. So this means that the court must be sure that the marriage is not salvageable, and it could not be saved. And based on that, the court would grant a decree of divorce. And that would mean also that would be one of the legal consequences of divorce. There might also be some personal consequences. Now we think about not on the legal side, but more towards the personal consequences. Obviously, it would include some emotional challenges. No divorce is pleasurable for any of the parties. And spouses often feel and often find it difficult to accept that the marriage is over, and they want to try and reconcile for whatever reason by seeing a marriage counselor before pursuing a divorce. But at that stage, once you get to a point that you realize that the marriage is not salvable, and it could not be saved, and that they have irreconcilable differences between the parties, and it's time for the divorce, there might also be some emotion involved with regards to one of the consequences. Patrimonial consequences. Now, patrimonial consequences is, like I said, the parties are no longer one union anymore, and the spouses will need to have to decide on how do they split their assets and the debts, depending on how they were married. The matrimonial property regime. They need to make provisions for things like child maintenance, for spousal maintenance, who pays the debt, who carries the burden of taking over the matrimonial home, and so forth. Those are all the financial implications that we deal with under the patrimonial consequences of the marriage. Now, redistribution orders, right at the top right. When spouses are married out of community of property with the inclusion of the accrual, then the spouses will actually then share equally in the growth of the estates of the other person. So that is now with marriages outside of community of property with inclusion of the accrual. However, there is no sharing of assets when they're married outside of community of property with the exclusion of the accrual. Those are all the nuances that your legal practitioner, your family law practitioner would be able to explain to you, because that might have a direct influence on your financial situation. Redistribution orders we usually find when we use that before the enactment of the Matrimonial Property Act. That's usually before the 1st of November 1984, that there is a way that the spouse can still claim from the estate, even though they were married under a different property or matrimonial regime. But those are only pertaining to distribution orders, only pertains to marriages before 1984. If you are married before 1984, please bring that to the attention of the attorney, and they might actually work with redistribution orders. Forfeiture of benefits, that is quite obviously, that is like I explained, that is usually in the event that the court makes an order in terms of Section 9(1) of the Divorce Act 70 of 1979. And Section 9(1) basically reads that when a divorce decree is granted on grounds of the irretrievable breakdown of a marriage, the court may make an order that the patrimonial benefits of the marriage may be forfeited by one party to the other in favor of the other party, either wholly or in part. If they look at certain circumstances and it actually warrants the bringing of such or making such an order. And the circumstances that the court would look at is basically what is the reasons that gave rise to the breakdown of the marriage, the conduct of one party, what did they do, and if the court then is satisfied that it is in order to make such an order for forfeiture, they will make that type of order. Next would be divorce settlements. That could also be a consequence of divorce. Now, reaching settlements in divorces are fairly quick, and it's a very efficient way of handling your divorce and bringing your divorce to an end. Now, reaching settlements means that the divorce would be uncontested. So, with other words, there would be no need for formal litigation, and the parties simply complete and they agree upon all these consequences, the legal consequences, the patrimonial consequences, who gets the matrimony in the home, and so forth. If they decide on that and if they agree on that provisions, then a settlement agreement could be drafted, and that could be handed up in court, and the court would then entertain that order and make that an order of court and incorporate that in the divorce decree. So that is one of the reasons why the attorneys would ask the parties if they are amicably willing to settle this whole matter without the need for formal litigation. But very often it is not possible. I might also add that about 98% of cases never ends up informally in court with formal litigation, and most often about 98% of these type of cases would be settled out of court, even if it's just a day before the formal court hearing. Coming through or looking at some of the other consequences of divorce, the matrimonial home. Yes, who gets the home? Because obviously once the parties split up and the divorce decree has been granted, one party needs to move out because they cannot stay together anymore. They're not considered to be one union anymore. And that usually creates a conflict Now, the matrimonial home would depend hugely on the type of matrimonial marital regime that you were married in order to establish on whose name is the property. Is it on both parties' name? Is it only on one party's name? And that would have a direct influence on where who can stay where after the dissolvement of the marriage. A question that always comes up is that, can you stay in the matrimonial home during the process of divorce, or should you move out? I usually advise my clients, and that is the legal stance at this stage, is that you cannot be forced to vacate the communal property or the common property up until the stage that the court actually makes an order of the dissolvement of the assets. So up until that stage that the judge or the magistrate grants the order of divorce, you are entitled to stay in the common household for that period of time. Spousal maintenance is also something that needs to be looked at. That is because during the course of the marriage, there is a reciprocal duty of support, but that duty might also be extended after divorce. So you would be entitled to ask for spousal maintenance after divorce. The court looks at a couple of factors. How long has the marriage been going on? Have you been working during that time? What was your contribution to the household, and so forth and so forth? What is your age? Are you willing and able and capable of being gainfully employed afterwards? Those are all the factors that the court would look at. Just bear in mind that if you would like, or you want to ask for spousal maintenance, that you can only ask this during the divorce process. Once you are divorced and the union between the parties are no longer there, then you cannot go afterwards, after the fact, and approach the court for spousal maintenance. So spousal maintenance needs to be dealt with and addressed during the course of a divorce. Those are the consequences, the general consequences of divorce. If I can just go to the next slide. Like I said, and that's just basically what I have just explained, the termination of the marital union, the legal duties and the responsibilities that are dissolved, and so forth. We've dealt with this in the previous slide. So next up would be, what are the 3 basic steps of a divorce procedure? Now, any divorce, if it is a contested divorce or even an uncontested divorce, would basically consist of 3 main elements. The first would be the preparation phase. Usually, if you employ an attorney, that would involve a consultation where the parties discuss, or you and your attorney discuss the matter, and the attorney would get some information. They would prepare the file in order to prepare the documents needed to approach court for a divorce. Once the consultation has been done and you get all the information, such as your marriage certificate, if there are children involved, the details of the children, who's getting what, an establishment of what type of marital regime we are talking about, only then the summons could be prepared, and that could be submitted for issuing at court and then be served on the other party. So that is still in the preparation phase. After that, once the summons has been issued and served on the respondent or your soon-to-be ex-husband or wife, then the process of filing of pleadings start. Now, pleadings are documents that are exchanged between parties and or attorneys, if you are legally represented. Those are the documents that are prescribed, that needs to be exchanged between the parties, so that the matter could be brought to court, and the end would be the formal trial at court. That is the third process, or the third step in the whole process of a simple divorce matter. Now, in my practice, I've seen many, literally thousands of divorces, and I've dealt with most of them. And I've realized that there might be some common mistakes that one should avoid during this whole divorce process. Number 1 is not getting proper legal advice. If you are married out of community of property with the accrual, without the accrual, or even inside community of property, that has a direct influence on you as the applicant financially. So if you do not get the correct legal advice, you would not know what your rights are and what you are entitled to in terms of the divorce. So getting proper legal advice is paramount. Get as much detail and as much information. There are books there on and so forth. Google is not always your friend, so do not rely on Google to give you all the answers. The best would be to contact either a legal practitioner, or if you cannot afford a legal practitioner, to go to legal aid for them to assist you and explain to you what your rights are and what you are entitled to. One of the other common mistakes would be making decisions based on emotions. When one party come to me and they and during a consultation, and they say they absolutely do not want anything from the other spouse, they just want to get rid of him or her, and they just want the divorce. Now that is a long-term problem that might be created based on a short-term emotion or emotional feeling. So do not make emotional decisions right off. Rather get the information, let it fester, let it ponder, think about that, think about your future and your life after divorce. So do not make hastily decisions based on emotional feelings at that stage. Hiding of assets, that is also a common mistake. Usually what happens is that one of the parties would start hiding the assets because they do not want to split the assets. For example, if you're married in community of property and you have to give half of the property to the other party, then they start hiding the assets. Now, the hiding of assets is not that uncommon during divorce proceedings, but it also has certain implications, and there are certain remedies for the party on the receiving side if they realize that the other party, or the soon-to-be ex, is hiding assets and property, bank accounts, and so forth. Then there are certain remedies, and we'll be discussing that in future webinars as well. So my advice would be is do not try to hide the assets, because there is always in terms of the South African law, there is always a paper trail, and those assets will be found. If it's not by the one party telling the attorney that the soon-to-be ex is hiding assets, definitely during the exchanging of pleadings, during the discovery phase thereof, these hidden assets would definitely come to the fore. With regards to that as well, and that ties in with not getting proper legal advice, I found that many people do not consider, especially when it comes to settlement agreements, they do not consider the tax implications of the settlements. So be careful, be wary about that, and speak to your legal practitioner specifically about the tax implications, because I've seen it so many times that the one party is so happy to get a settlement, and they get the money from the pension fund, and then they get slapped with one hell of a bill from SARS, because they need to pay the tax thereon because it was not properly mentioned or properly addressed in the settlement agreement. So be very careful, be very cautious about the tax implications thereof. Failing to communicate effectively is also one of the common mistakes that people make. They grey rock the people. They do not want to talk to the other party, speak to my lawyer. Those are all the scenarios that comes to mind. Failing to communicate would only delay your process. If you fail to communicate and to try and to resolve this matter as amicably as possible, then the matter could be drawn out. Now, for some people, it might be beneficial in order to prolong this whole process, but very often I've found that the longer the process drags on, the more money the attorneys make, and the less the parties would actually get out of this whole divorce process. So failing to communicate is a serious problem, especially when you have an acrimonious divorce and we only have attorneys speaking to each other. That is a costly exercise. But remember that with all weddings and all marriages, at one stage, that person was the person that you wanted to be with. So you communicated during that stage. So for you, the benefit of all the parties, it might be to your advantage to actually have an open line of communication, especially when there's children involved. That brings me to the next point, ignoring the needs of the children. Now, in terms of the South African legislation, no court would grant a divorce if it's not in the benefit of the children. That's why we have the offices of the family advocate. They are there to oversee that the needs of the children are met before a court may actually grant a divorce order. And that is one of the common mistakes. People, the parties are so tied up with their own emotional feelings, their own hurt, their own vengefulness in getting back to the other party because they do not want a divorce, that the children's needs are often not attended to. Remember that during this whole divorce process, you have a choice. You always have a choice of being in control. And if you could use the process to your advantage to be a survivor rather than being a victim. That is just the common mistakes that I found in practice is usually made. So what we'll do now is we'll turn over to Erin so that she can discuss with us the differences between the contested and the uncontested divorces, just to give you a general idea of the two processes that could be followed.
We will now look at the difference between a contested and an uncontested divorce. So in South African law, there are two types of divorce processes. You have a contested and an uncontested divorce. The processes are slightly different, and we will look at them briefly now. Before you institute a divorce, you have to determine what type of marital regime you are married in terms of. So there are three types. You have marriage in community of property, marriage out of community of property, marriage out of community of property subject to the accrual system. So this is determined by means of an antenuptial contract. So I will just briefly discuss each. So marriage in community of property means that you now have a joint estate. So both spouses' assets and liabilities form part of one joint estate. What's yours is mine, and what's mine is yours. Marriage out of community of property means that there are two separate estates. What's mine is mine, what's yours is yours. There's no joint estate, their estates are kept separate. And then marriage out of community of property subject to the accrual system means that you share in the growth of the spouse's separate estates. So before marriage, what's mine is mine, what's yours is yours. But everything that we accrue together during our marriage, that forms part of our accrual. So your separate estates, you will share in the accrual thereof. In terms of the divorce process, we have stated now, we have contested divorce and an uncontested divorce. So a contested divorce is when the spouses are unable to agree on the terms of the divorce. Various factors play a role here. So you are in disagreement regarding how various assets should be divided. You are in disagreement about how the minor children should be approached in terms of a parenting plan. There's just disagreement based on various factors. Then you will have a contested divorce. It is advisable to approach a specialized divorce attorney if you have a contested divorce. This is due to the fact that there are various problems arising from this. You and your spouse are in disagreement. There might be conflict. And as such, you will require an attorney to help you understand what you are rightfully entitled to in terms of the divorce. And then also, this would lead to a formal trial. If you are going to contest the divorce, you will have to go to trial. This means that various pleadings have to be exchanged. You, as the person wishing to institute the divorce, will institute it by means of a divorce summons and a particulars of claim. And then the spouse, who now wishes to contest the divorce, will institute a notice of intention to defend. And these pleadings will be exchanged between the attorneys until it leads up to the trial. In terms of a contested divorce, it is the court that often makes the final decisions. This means that you as the spouses have little say over what will happen with the division of the assets and the minor children, as the court will make the decision and will be put in the divorce order. Therefore, it is actually advisable to try and settle outside of court, as you as the parents of the minor children and you as people are placed in a better position to make decisions regarding your own lives. As such, it's always advisable to settle outside of court. This would mean instituting a settlement agreement, which you come to agreement on various terms of your divorce. And if there are minor children, you can draw up a parenting plan. And then the parenting plan will set out how maintenance for the children, guardianship, care, and contact, how all of that would work in terms of the children. That brings me to the next type of divorce, which is an uncontested divorce. This is where the parties are in agreement regarding all the terms of the divorce. They are in agreement regarding how assets should be divided, in agreement regarding how the children should be raised, how care and contact will take place. This is also a less expensive process than a contested divorce because you do not have to go to trial. Only one party needs to be in court on the day of the divorce. The settlement agreement and the parenting plan that was drawn up will form part of the divorce order. And so, therefore, it is advisable to have an uncontested divorce. It is less expensive, and it takes up less time than a contested divorce, given that you don't have to go through a formal trial. Thank you. Back to you, Eugene.
Thank you for that, Erin. Just to reconfirm what you said, that obviously the unopposed divorces, the uncontested divorces, are the easier process. In my practice, we try and lean towards that because it is more amicably suitable for both parties. They both benefit, and it is an easier process in order to get a divorce decree. What I very often do, I make use of mediation, where I would get the parties in. I would bring them to my office and I would discuss the matter with them. Obviously, when both parties are present, trying to reach an agreement. Very often, I get people coming to my office and they say, but they've already spoken to the ex or the soon-to-be ex-spouse, and they already reached a informal settlement. And then what we basically do is we just redraft the settlement proposal, the consent paper that needs to be filed at court. This could be done, and I'm a very good advocate for that, is that to draft a settlement document even before you issue summons. So it's not necessary. It could be done afterwards. It happens quite often. If the divorce starts off as a contested divorce, people are very acrimonious, and then at the end of the day, they see eye to eye and they reach a settlement agreement. So that could be filed at court afterwards. But in my instances, specifically when it comes to unopposed divorces and the parties want to agree and they want to work together, my advice would be to draft a settlement agreement beforehand, even before you issue summons. And you can include that as part of your particulars of claims, stating that the parties have actually reached a settlement and they want to make the settlement a part of the divorce decree. So what would happen if we go through some of the steps of the unopposed divorce? A settlement agreement would be signed. Parties sign the settlement agreement. If there are children involved, the Office of the Family Advocate needs to be involved. Usually the settlement agreement gets sent to the Office of the Family Advocate. In that consent paper or the settlement document, there would be provisions for the children, such as maintenance that needs to be paid, visitation rights, who shares the parental rights and responsibilities, and so forth. And that gets scrutinized by the Office of the Family Advocate, and they send out a letter back to the attorney as well as to court, saying that they endorse that they are happy that the provisions of the children are met and that the divorce may proceed. So that forms part of the settlement agreement. The next step then would be, after the settlement agreement has been signed, is to issue summons. Now, the summons is basically just legalities and paperwork that needs to be signed or to be drafted, and it gets signed by the attorney. And then the summons is personally served. It needs to be personally served upon the defendant. what I do in my practice, because the parties are not acrimonious, and they are willing to sign the settlement agreement, I would phone up the sheriff of the court needing to serve the summons, and I would tell them, listen, the respondent would come to your office to come and collect the summons at the sheriff's office. Then there's no need and there's no embarrassment of having those documents signed and delivered and served upon you at your workplace or your place of employment or at home or whatever in front of the children. So if usually in uncontested divorce, I make that arrangements with the respondent to go to the sheriff's office to go and collect the summons directly from there. The next step would be the preparing for the hearing. Obviously, you need to get if there are children involved, you need to get the documents from the Office of the Family Advocate. There would be a final consultation with a client, just to explain to them what is the process that will be followed at court, and just to wrap up everything. Once that has been done, the court file needs to be prepared so that the magistrate or the judge looking at the file would know what's going on, that everything is in order, that all the documents have been submitted. And then there's a process that we call indexing and pagination, where you have basically to draft an index of the documents that would be submitted and would be discussed at court, as well as the page numbering thereof, so that everybody's on the same page. And then the matter would be set down for hearing, for trial, and on the unopposed roll of divorces. What happens at court, then the matter would obviously go to court, and then the plaintiff would be questioned. They would be asked a couple of questions, which we will go through, and there would be a confirmation of the parties' signatures on the settlement agreement. Typically, what we would ask is that do you confirm that you signed this on that date? Do you confirm that this is your signature? Is this the signature of the respondent? And then the attorney would ask that the settlement paper or the consent paper would be handed up and form part of the divorce decree. And then at the end of the day, once the magistrate or the judge is satisfied that everything is in order and that the parties indeed consented to a settlement agreement, then they would make an order for divorce. That is the simple process of an unopposed divorce. Regarding costs, yes, obviously, like Erin also mentioned, the cost of a divorce in South Africa differs. Some attorneys work on a fixed rate. Some attorneys work on a billable hour system, where you get charged for every telephone call, for every WhatsApp sent, for every pleading that has been drafted and exchanged. So the costs of divorces differ. I've seen people attorneys doing divorces for up until 2,000 or 3,000 rand, and I also dealt with divorces in the High Court specifically that ran into a couple of million rands just for legal expenses. So obviously the opposed divorces are much more expensive, where the parties are acrimonious and they have to fight, because it is a more prolonged process of litigation. The attorneys and advocates might be involved. There are numerous pleadings, discovery notices, who's going to lead what type of evidence, expert witnesses, and so forth. So there's much more court preparation that needs to be done specifically in opposed divorces, and that makes it quite expensive, as opposed to the unopposed divorces. The uncontested divorces, obviously those are much cheaper because it's faster and it's a more amicable process. The people or the parties have reached a settlement. There's much less paperwork to be done, and there's also there's not necessary involvement of expert witnesses and testimony that needs to be led at court, which would lead to lesser court time, and which you will not be charged for. So that is just, in short, the cost aspect of divorces in South Africa. Next, we will have Erin explaining how you could actually prepare a divorce summons yourself. So it is not needed that a divorce summons be drafted by an attorney. There are ways and means that you could do that, but be very careful, be very wary from my side as well, that you do not venture into this realm of issuing your own divorce papers and then at the end be shot in the foot because you did not know all the legal expertise or the legal nuances that might be applicable specifically to your marital regime. But I'll hand over to Erin so that she can explain to you how to draft a divorce summons yourself. Over to you, Erin.
Now we will discuss how you can prepare the divorce summons yourself. So as a point of departure, it is entirely possible for you to prepare the divorce summons yourself. You do not have to approach an attorney. However, it is advisable that you do this only if you have an uncontested divorce and if you have no assets of substantial value. If it is a contested divorce or you have assets of substantial value, it is always advisable to rather approach a specialized divorce attorney to guide you through the process and help you institute the divorce action to ensure that you get what you are legally entitled to. But for this focus would be on an uncontested divorce. You are able to successfully institute divorce proceedings on your own, and this is done either in the High Court or the Regional Magistrates Court. So as I've said before, if you wish to institute divorce proceedings, it is done either in the High Court or the Regional Magistrates Court in the area where you are either domiciled or have been ordinarily resident for a period of at least 1 year. Let's get right into it. So you are able to successfully institute a divorce summons on your own. However, you have to understand how to do this. So you can obtain a divorce summons from the court. So you can obtain it either at the High Court or at the Regional Magistrates Court. The purpose of the divorce summons is to inform your spouse that you intend to divorce him or her. The divorce summons is then served by the sheriff. It is important to understand that the divorce summons is served by the sheriff because you would need the return of service to prove that you have actually served the summons on your spouse. So this means that you cannot fill in the divorce summons at court and then hand it to your spouse yourself. You have to take it to the sheriff's office, and the sheriff will then serve this document on your spouse. It is important to understand that the divorce summons actually has two parts to it. It is the face of the summons, and then you have the particulars of claim. So the particulars of claim contains the most important information. So once you have served your divorce summons on your spouse, that spouse then has 10 days within which to inform you and the court of their intention with regards to the summons that was served on them, to give their notice of intention to either defend the divorce, so meaning it becomes a contested divorce, or they can give their intention not to defend the divorce, meaning it's an uncontested divorce. So it's quite simple, but it should be also noted that the particulars of claim of your divorce summons sets out the grounds for your divorce. So the following details are contained in your particulars of claim and not in the divorce summons itself. The divorce summons merely informs your spouse that you intend divorcing them, and then they have 10 days to notify you in the court whether they wish to defend the action, or if they are not defending the action, it would be an uncontested divorce. So the particulars of claim, which is the most important document, contains the following information. The information is set out in paragraphs. So it contains your details, your name, your identity number, your address, and what is your occupation. The same goes with your spouse. It will contain their name, their identification number, their address, their occupation. It will set out the jurisdiction of the court, so where you are domiciled or ordinarily resident for a period of at least 1 year. Details about the marriage, so when was the marriage entered into, the date of marriage, where did you guys get married. It will also deal with the minor children. So if you have children, it will deal with the children, such as how old are the children, their names. You will attach their birth certificates. You will attach their school reports. It will also deal with care, contact, guardianship, and maintenance of the children. Breakdown of the marriage. So why was your marriage irretrievably broken down? So the particulars of claim will extensively set this out. For example, we have discussed the various factors that a court considers to determine whether there has been an irretrievable breakdown of the marriage. Often these factors are also set out in the particulars of claim. They're set out in separate sub-paragraphs. For example, miscommunication. There's no communication between the spouses, that you have been living apart for a period of at least 1 year, for example. It will set out, for example, that you no longer trust each other, that there was infidelity. All of this is set out in your particulars of claim to satisfy the court that there has been an irretrievable breakdown of your marriage relationship and that there's no reasonable prospect of the relationship being restored. This has to be set out in your particulars of claim. Your particulars of claim will then deal with the pension funds, which must be addressed, your pension fund, your ex-spouse's pension fund, and then, as I've said, the care and contact guardianship of children is also discussed in the particulars of claim. So just to reiterate, the common grounds for a breakdown of a marriage will be discussed. Pension funds is also addressed. If you were married in community of property, that means that both spouses have a claim towards each other's pension funds. That is why it is important that it must be discussed. And then also care and guardianship of minor children. Where will the children primarily reside? How often can the non-custodian parent see the children? Holiday arrangements. What maintenance will be paid towards the children? How long will the maintenance orders be in place? What will happen during birthdays? And then something that should be always remembered is the family advocate must approve your arrangements with regard to the care and contact of your minor children. And if the family advocate is not in agreement with the proposed arrangements and is not of the opinion that it's in their best interest, the divorce will not be granted. So once all of these factors have been addressed, you need to add an addendum with documents such as your identification document, the identification document of your spouse, the original marriage certificate or a copy thereof as obtained by the Department of Home Affairs, the birth certificates of the children, and any other documents that might affect your marriage. Once this is done, once your divorce summons is compiled, once your particulars of claim sets out all the factors, once all the documents are attached to your divorce summons, you can approach the sheriff, who will then effect service of the summons on the spouse. And then always remember, you need the return of service from the sheriff to show the court as proof that a valid service occurred on the spouse. Failure to follow these steps will most likely result in the court refusing to grant your divorce. So it is clear, it is very easy. You just approach your local regional magistrates court or the high court to obtain the divorce summons. You set out all those factors in the particulars of claim. The document is then taken to the sheriff's office. You will pay the sheriff's fee. He or she will then serve the document on your spouse. Your spouse will either defend the matter or they will not defend it and it becomes uncontested. And that is the process of instituting the divorce on your own. Thank you. Back to you, Eugene.
Thank you for that, Erin. Yes, what I would also do is I will, in the resource and tablet and template folder, I'll put up for you to download the standardized form that is issued by court if you want to do it yourself, as well as one or two examples of what a divorce summons look like. Obviously, I would redact the names of the parties and the children in there as well. That basically brings us to the end of our session for today. Just as a general reminder, we have written a couple of ebooks that is available free for download. There is a QR code that you can scan, or you can visit our website on www.oppermansinc.co.za for the download of these ebooks. There's a couple of them that specifically deals with divorces. The one is things that you should know before divorce. There's also one pertaining specifically to same-sex marriages, discussing the Civil Unions Act, divorcing a narcissist, what to expect and how to deal with narcissism when it comes to divorces. We will also be addressing that in future webinars during the course of the week. Specifically, how do you deal with a narcissistic person? Another ebook that it might also be of interest if you have minor children is the maintenance, what you should know about maintenance. for the children as well as for the spousal maintenance. You can have a read through that beforehand. And then our last ebook in the range was one about divorcing with dignity, where you could still keep your dignity while going through the whole divorce process, where we focus very much on mediation and how to take self-care of yourself during this whole process of a divorce. Thank you so much for joining us today. This again was sponsored by our legal firm. We are based in Gordons Bay in the Western Cape. If you have any questions, any inquiries, please feel free to reach out to us, and we'll be most happy to assist you and to guide you in the right direction. If you have any comments, you can also include that and drop us an email. We would love to hear from you. Thank you so much. Please do read the disclaimer right at the end, and then we will be seeing you for another session of Lunch and Learn this for tomorrow, dealing specifically with divorces during the Divorce Week project that we do for the public at large. Thank you so much for joining us. We'll see you tomorrow. For those that have registered, for those that have not registered, please do so on our website, www.lunchandlearn.org.za, and we will be seeing you tomorrow. We will be discussing further aspects of opposed divorces and what the process thereof is, and we'll be discussing in future or upcoming webinars. We will be discussing issues like in the hiding of assets and so forth, specifically dealing with maintenance, dealing with narcissistic people. We'll be discussing that during the course of this week. Thank you so much for joining us. My name is Eugene Opperman. I'm a family law practitioner specializing in divorces, maintenance matters, domestic violence as well. And it has been an absolute pleasure in hosting this webinar for you today. Thank you so much for joining us. And then we can knock off and say thank you to all of those that attended, and we see you tomorrow. Thank you so for joining us, and have a good afternoon further.